Good morning, everyone. My name is Chris Hone, and I'm with the law firm of Thompson Coburn. I wanted to welcome everyone to today's webinar called Better Together, Competition, Price Gouging, and Other Antitrust Issues Raised by the COVID-19 Pandemic. Before we start, I want to just give a few housekeeping details to everyone. If you have any questions at all during the webcast, you can submit them through the Q&A widget at the bottom of your screen. We will try to answer these during the webcast, but if a fuller answer is needed or we run out of time, we will answer it later via email. Also, a copy of today's slide deck will be available in the resource widget. We encourage you to download any resources or links that you may find useful. You can find additional answers to some common technical issues located in the help widget at the bottom of your screen. And finally, probably most importantly, this webinar is approved for 1.2 hours of general CLE credit in Missouri, 1 hour of general CLE credit in California and Illinois. CLE credit in Texas is pending. We will award CLE based on attendance for the entire 60 minutes. From time to time, you'll be required to click a pop-up screen to reflect your continued engagement. We truly value your opinions and appreciate your participation in the course today. So let's start. The COVID-19 pandemic has caused unprecedented impacts in our personal and work lives. We all know that. But it has also produced both new challenges and some new opportunities in how firms in the U.S. economy compete with one another and collaborate with one another, advertise their goods and services, especially those that are essential to consumers at this time, in how firms price their goods and services, especially in times of high demand in a number of sectors. So today we're going to discuss these antitrust-related issues in this webinar. And with me today are my colleagues, and that includes Nicole Williams, Felicia Williams, Steve Shrettle, and Jasmine Wynn. We are privileged and honored that you could join us today, and we hope and think that you will find this material very informative and helpful in helping guide your firms. So let's do a quick overview of what we're going to cover. We're going to cover three primary areas in today's webinar. And the first is competition, and you'll hear from Nicole Williams on that. She's going to talk about competitor collaborations at this time, guidance from the FTC and DOJ regarding those issues on collaborations, and new agency procedures that she will elaborate on. Secondly, the second component of our webinar is going to be false or deceptive advertising. We're going to hear about the recent FTC and FDA guidance, and we're going to provide watch-outs, especially with respect to advertising of health and safety equipment and supplies. Finally, our last topic will be price gouging issues. We will take you through a tour of some of the patchwork of state laws that relate to price gouging and pricing in times of emergency such as this. We'll also talk about some recent federal pronouncements in that area of price gouging. And finally, we'll have time at the end for questions and answers, as I mentioned. So I'm going to kick it off at this point and hand it over to Nicole to get us started with competition.
Thank you, Chris, and welcome everyone. Hope everyone's having a good morning, and thank you for joining us. I want to just kick it right off with some statements that the agencies, and when I refer to the agencies, I'm discussing the Federal Trade Commission, or FTC, and Department of Justice Antitrust Division, or DOJ, which are the two primary federal enforcers of the antitrust laws here in the U.S. So I want to kick it off with some statements that those agencies have made since the crisis, talking about how competition and the antitrust laws are going to work during this time. So you'll see that most of these come from a statement released on March 24th, which was a joint antitrust statement regarding COVID-19. And some of these other ones that you may not recognize from that statement come from interviews that have been given with various FTC commissioners and staff. And basically, the agencies have alerted folks that they understand that the current crisis is going to require some unprecedented cooperation, including among private businesses. And I want to remind everyone that there are many pro-competitive ways that don't violate the antitrust laws that allow people to collaborate and react to this crisis. A lot of what we're going to talk about here today is already in prior agency guidance, but we're going to put a little COVID-19 spin on it. One of the things that's been referred to in a lot of the statements are that the agencies are going to account for exigent circumstances. So they're going to take into account what's happening in the world right now and what businesses need to do to respond. That doesn't mean, as we'll talk about later, that the antitrust laws are on hold or that there's any kind of exception. That's certainly not the case. The agencies have made that clear. But they are going to take into account what are your businesses trying to do, and are there legitimate reasons to do that, and are there legitimate benefits that are going to come from businesses coming together. One thing that's important to note is they've referred to joint efforts that are limited in duration and necessary during this time of crisis. And one of the things they've specified is that means you're assisting patients, you're assisting consumers, you're assisting communities that have been affected by COVID-19, or that you're providing Americans with products or services that they might not be able to otherwise get. And we've certainly seen that that's the case, that without companies stepping up and working together and sharing resources, there are some things we're just not going to be able to do. So those are the types of things they're referring to with these COVID-19 statements. Recently, in fact, just yesterday, the FTC released some comments from their Bureau of Competition director, and he outlined some of the complaints they've seen thus far about competition. And he recognized that what these complaints are about is really run-of-the-mill antitrust violations, which would include just naked price fixing between parties, coordination that actually doesn't have anything to do with or doesn't address the crisis, that's just using the crisis as an excuse, or that isn't output enhancing, meaning that the coordination isn't actually helping get things out into the marketplace and serve people, but is in fact doing the opposite. So let's talk about what some of the prior DOJ and FTC guidance is. And like I said, this is going to be the bedrock of a lot of the comments that the agencies are making, and this is what they're going to go back to for their analysis of things that are happening now, even during COVID-19. And you'll see some of these are a little bit old, but they are still in effect and being used by the agencies. There aren't more updated versions. So we have the Competitor Collaboration Guidelines released in 2000, the Statement of Antitrust Enforcement Policy in Healthcare released in 1996. Over the years, they released various FTC advisory opinions, DOJ business review letters, and then there's a number of, like the COVID-19 statement, other enforcement statements that are released, along with the actions, the consent orders, and the judgments from the enforcement actions that the agencies bring. So a lot of what I'm talking about today comes from these sources. So competitor collaborations. What we're talking about on this slide are competitor collaborations specifically mentioned by the agencies as part of their COVID-19 comments. But these concepts, like I said, are already in the prior guidance. And so there really isn't anything new here, just to highlight by the agencies that these are some of the things they think might be helpful during COVID-19, and they want to remind businesses that they've already given guidance that this activity can be pro-competitive and can be very helpful. So what have they specifically mentioned? They've mentioned research and development collaboration, which is recognized as generally pro-competitive. There are even some safety zones for certain activities within the competitor collaboration guidelines. They've mentioned sharing technical know-how that allows companies to do things they may not otherwise be able to do. They've recognized that businesses in this time may need to temporarily combine production, distribution, or service. Those are what we normally refer to as production collaborations, buying collaborations, distribution collaborations. And then they've also mentioned private industry meetings with and lobbying to the federal government. So the general efficiencies that are noted in the antitrust guidance for these types of collaborations that they're highlighting is that participants in these collaborations can offer goods and services that are cheaper, more valuable to consumers, or brought to market faster than would be possible absent the collaboration. And bringing to market faster is certainly something that's necessary during this time for a lot of different things. Also, they've noted that these types of collaborations can allow participants to better use their existing assets or provide incentives for them to make output-enhancing investments that wouldn't occur without the collaboration. So examples in this time are facilities that may not need to produce what they normally do because there's not a demand for that at this time, but then demand is exceeding capacity as to other products. And so sharing technical know-how and also combining production and distribution can be very helpful for businesses to pivot and help produce more of what we actually need and not waste time or resources on things that we don't. Also, the competitor collaboration guidelines have always recognized that the business purpose of an agreement and the subjective intent of the participants, while not binding, are part of the analysis. And so the current comments from the agency are a reflection that if your efforts in collaborating are truly to respond to the crisis and to do things to help the economy and the American people, those factors are going to be operating in the collaboration's favor, and the agency is going to take that into account. Now, these statements on this slide are not in the COVID-19 guidance, but they are in the competitor collaboration guidelines that I mentioned before. So although these were not specifically highlighted by the agencies as part of the crisis, I think it's important also to go back to those guidelines to see some of the other things that they've referenced are generally pro-competitive. The collaborations to jointly produce products are often pro-competitive. And what's pro-competitive about those, as recognized in the guidelines, is that you can produce goods more efficiently, or you could produce a good that not just one of the participants in the collaboration alone could produce. And I think this is going to come a lot into play during this time. Now, the negative, potentially anti-competitive aspects of that kind of joint production agreement are that you need to avoid agreements on the level of output, the use of key assets, and the price of your products. So we need to try to avoid some of the price fixing, output eliminating agreements that people are sometimes worried about. And the same for marketing and buying collaborations, which are agreements either to jointly sell and distribute or agreements to jointly purchase necessary inputs. These can be really helpful because they get products more quickly and efficiently out in the marketplace, which we certainly need now. But companies need to be very careful that you're not standardizing costs, you're not agreeing on output, you're not agreeing on prices, and you're not affecting the independent decision-making of the company. Healthcare collaborations have also been a big part of the COVID-19 comments. So the quotes on this slide are coming from the agency's post-COVID-19 comments. And they highlight a few things that are not issues as recognized under the previously existing healthcare statements. So those are practice parameters for healthcare providers, joint purchasing arrangements, and facilities providing resources and services to communities that are having trouble getting access to these items. If you go back to the competitor collaboration guidelines as to joint purchasing arrangements specifically, they've recognized that the pro-competitive aspects of that are increasing efficiency of procurement and reducing transaction costs. So for example, volume discounts. And those are two things that are certainly of importance to healthcare providers right now. Some examples from the healthcare statements of what would be pro-competitive arrangements are coordination of laundry or food services by hospitals, computer or data processing services by providers, and purchases of prescription drugs and pharmaceuticals. If we go to the healthcare statements, these are some additional items that have been recognized as generally not creating antitrust issues that have not been highlighted by the agencies in this time, but that might be of importance. The first is from Statement 2, which addresses that generally hospital joint ventures to procure or to operate high technology or expensive equipment are generally pro-competitive. And the second is Statement 3, which discusses hospital JVs for specialized clinical or other expensive healthcare services. And both of these are designed to help providers get things into the marketplace that they might not be able to justify themselves. Healthcare collaborations have been the subject of the only business review letters we've seen thus far after the COVID-19 crisis. One is discussed in this slide. A very similar one was issued yesterday to AmerisourceBergen. Both of these business review letters address efforts by healthcare suppliers to assist FEMA, HHS, and others in sourcing, distributing, buying PPE, and the one that was issued yesterday addresses medicine and other medical supplies. Because they're assisting the federal government these don't have much effect beyond these letters themselves or folks who are participating in that effort. But this is what we have from the COVID-19 guidance so far. And the DOJ has noted they don't intend to challenge any of these efforts by the medical suppliers to get things out there where they need to be. They have noted that these are efforts to help the U.S. government, and that's certainly part of their analysis. But they've also given some other guidance that's helpful generally. They've noted that these coordinated efforts are limited in duration and as necessary to assist the patients, consumers, and communities affected by COVID-19. So that's certainly something the agencies are looking at. They've noted that without this coordination, the supplies might not otherwise be available, and so that's something they're taking into account. Importantly, they're noting that the collaboration is not going to increase prices, reduce output, reduce quality, or allow the firms to engage in profiteering. So those are certainly some of the things that the agencies are concerned about. And they also noted the limits on information sharing among the competitors in these arrangements. In these particular cases, the data is only being provided to the federal government. We'll discuss a little bit later what you do where that's not your situation, and information does actually need to be shared between the competitors. So the overall agency messages are they're continuing investigations, they're continuing enforcement. The agencies have not shut down. But the agencies are going to be reasonable and flexible and take into account where companies are acting in good faith to provide necessary goods and services to customers. But that doesn't mean there's an emergency exception to the antitrust laws, and the agency is very aware that they've heard what they call whispers that companies are planning to use this crisis as an excuse to violate the law, and that's not something that they've said they're going to tolerate. So what are their areas of concern? On this slide, we highlight things that are not going to be okay in any collaboration, and that the agency is not going to look past due to any excuses or claims of good faith based on COVID-19. So the first is competitor agreements on pricing or output, what we generally refer to as price fixing agreements. So that would be where competitors are agreeing to raise or stabilize prices for any product or service with each other. You can still have a price fixing agreement even if you're agreeing to lower the price. The competitor agreements on pricing and output are something that shouldn't occur in the collaboration that you should be concerned about. They're also going to be on the lookout for bid rigging, where companies agree to manipulate competitive bidding processes, for customer or market allocation agreements, which would be where competitors agree to divide up customers or markets of a product or service. For example, you take the west part of the U.S., I take the east, you take this industry, I take the other. Those are not allowable agreements. They're going to be on the lookout for exclusionary conduct by monopolists or competitors who have market power. So they're going to be looking, are you trying to limit your competitors' access to supplies? Are you trying to lock your competitors out of the market with exclusivity agreements or something like that? Are you using predatory pricing on the front end, very, very low pricing to put your competitors out of business so that you won't have any competitors? And are you trying to tie products that people don't want to a product you have that they really need? So the agencies are going to be looking out for that. They're very concerned about information sharing. Now, there is information that you can share as part of the collaboration that's necessary to it. An example is the know-how that they referred to earlier, but prices, outputs, and costs are things that they're very concerned about. And certainly if that information is not necessary to your collaboration, it's not something that should be shared. And one thing I want to highlight for sure is the labor market collusion, because on April 13th, the agencies issued a joint statement regarding COVID-19 and competition in labor markets. Now, they addressed this enforcement guidance to employers, staffing companies, and recruiters, and especially for anyone that deals with healthcare workers or essential service providers. And they said they're on the lookout for and concerned about agreements to lower wages or reduce hours, unlawful non-compete or no-poach agreements, and companies sharing employee information. They're very serious about this release. They reference potential criminal action in it, and they also say they're on the lookout for invitations to collude, not just actual collusion by companies. And actually, pre-COVID-19, the agencies had recently challenged some offers by companies to agree to lower wages or reduce hours. So this isn't just part of the crisis, it's part of their ongoing enforcement action generally. So what can companies do to reduce risk? First, you need to make independent business decisions regarding pricing, markets, and other competitive decisions. So anything that's not directly related to the joint venture that you're entering into needs to be made independently. And you shouldn't be sharing competitively sensitive information. So the key is to share the least amount of information necessary to effectuate the goal. And you should also put in place NDAs and firewalls for any competitively sensitive information that is necessary to share. For example, if you're entering into a joint marketing agreement, there's no need to be sharing price or cost information. That doesn't relate to that. Similarly, on the agreements on competitive decisions, if you are combining production, there's no need to jointly agree on a price. And so you just need to make sure that all your agreements and all your sharing of information are directly related and necessary to what the point of the collaboration is. Now, another thing you can do at this time is utilize your existing antitrust compliance policies and training. This is a good time to remind your business that the antitrust rules are still in effect. And your high-risk employees in this area are those who deal with pricing or sales responsibility. For the labor markets, those that deal with HR, and anyone at your companies who encounter or talk with competitors as a regular part of their job. And if you don't currently have antitrust compliance policies or trainings, working on some quick do's and don'ts for those employees to help guide them during this time is a good idea. We're going to talk about agency notification and review procedures. There are some times when those are appropriate to use, and of course you can always discuss with your antitrust counsel any questions or concerns. I'm going to quickly run through agency review procedures. These are normal procedures that exist already, and the agencies have just made them a little more expedited. The FTC staff reviews and DOJ business reviews are where you basically send letters to the agency describing what it is you want to do, and then they provide you with a response. This can normally take months. These are public, but now they're giving responses in 7 days if it relates to COVID-19, and it's going to apply for 1 year. The second one at issue is the NCRPA. This applies to joint research and development activities and joint production activities. You can qualify for some preferential antitrust treatment. It eliminates the option of punitive damages, and it gives you some standards that are more helpful than the typical standards, but it does require you to register with the agencies. Something gets published in the Federal Register, so it is very public. They've mentioned they are doing expedited processing of this, but they haven't been specific as to how expedited. Normally it takes at least 30 days. And finally, the HSR. I just want to touch on this briefly. So that's the Federal Pre-Merger Notification Program. If you have large mergers and acquisitions that you need to announce to the agency, everything is going online now. Filings, reviews, and early terminations. The agency has said they're completely up and running and proceeding normally at this point, although they have seen a decrease in company activity during this time. E-filing has started. In fact, all you can do now is e-file. There is no current hard copies. And just one thing to note, if you are a potential buyer of a divestiture property, they are looking at current financial and economic stability and realities. And they are proceeding with the divested asset program, but they're using the current guidelines and they are going to want current information. So now I'm going to turn it over to Felicia Williams to tell you more about false and deceptive advertising enforcement.
Thank you very much, Nicole, and good morning, everyone. Thank you for joining us. Now, I'd like to start by discussing false or deceptive advertising. Faced with the current demand, businesses are scrambling to manufacture, sell, and ship vital health and safety equipment. Now, this includes hand sanitizer, masks, and disinfectant wipes. And other products like vitamins and over-the-counter painkillers are also flying off of shelves. I'm sure you've all experienced that yourselves over the last several weeks. Now, there are various government agencies that are responsible for policing online and in-store marketplaces to identify the businesses or individuals that may be misrepresenting the power and the effects of their products. And while these agencies deal with a number of issues on a daily basis, they have all bumped consumer protection to the top of their priority list in the midst of the COVID-19 crisis. And each of these agencies is working to eliminate any deceptive advertising for health, safety, and high-demand products. In January of this year, the FDA actually issued a warning letter to Gouging Industries. Gouging is the maker of Purell hand sanitizer, a very commonly used product for most of us. Now, the warning stated that Gouging lacks credible scientific studies and evidence to back up its claim that Purell hand sanitizers can prevent 99.9% of illness-causing germs. And while Gouging's claims at that time did not mention COVID-19 specifically, the FDA did note that Gouging's website contains statements that suggest its hand sanitizer might be effective against viruses such as Ebola, norovirus, and influenza. Now, since this time, both the FDA and the Centers for Disease Control and Prevention, the CDC, have both issued hand sanitizer guidelines that do support the use of hand sanitizer to inactivate viruses that are similar to COVID-19. These guidelines offer support that hand sanitizers prevent the spread of the virus. And currently, Gouging's website states that coronavirus disease 2019, or COVID-19, is caused by SARS-CoV-2, and Purell sprays and hand sanitizers kill similar viruses and therefore can be used against COVID-19 when used in accordance with the directions for use on hard, non-porous surfaces. And Gouging's website then refers consumers to the CDC's webpage for additional information. So they're currently in compliance. On March 9th, the FTC and the FDA jointly issued warning letters to 7 different companies that were allegedly selling unapproved products that may violate federal law. The advertised products include herbal teas, essential oils, and colloidal silver. The companies allegedly made deceptive or scientifically unsupported claims about the product's ability to treat or prevent COVID-19. But as we know, according to the FDA, there are no approved drugs, vaccines, or investigational products currently available to treat or prevent the virus. The companies were all informed to change their marketing in order to prevent the sale and promotion of fraudulent products, which are a significant threat to the public health. And just recently, on April 14th, the FTC's commissioner, Noah Phillips, spoke with a technology reporter for Politico. The two discussed how the FTC is dealing with scams related to COVID-19. Commissioner Phillips reported a dramatic increase in the number of scams related to the virus. In fact, consumers have filed over 13,000 scam complaints involving approximately $13 million in alleged harm. The complaints include bogus health claims, such as tests and cures for the virus, travel-related scams, and even businesses and individuals posing as government representatives. Now, the FTC's response to these scams has been three-pronged. First, the FTC's lawyers are sending warning letters to scammers, and this works to shut down the false claims in many cases. Second, the FTC is consulting with its partners at the state and federal levels, such as state attorney generals, federal prosecutors, and other federal agencies. For example, the FTC is sending joint letters with the FDA to shut down bogus claims of cures and tests. The FTC is also sending joint warnings with the FCC to address scam robocalls, and it's consulting with the Department of Justice on criminal fraud activity. And speaking of the Department of Justice, the department filed its first enforcement action for COVID-19 fraud against the operators of the website coronavirusmedicalkit.com. Now, the website claimed to offer consumers access to World Health Organization vaccine kits in exchange for a shipping charge of $4.95 paid online with a credit card. The DOJ claims that the website's operators are engaging in a wire fraud scheme and seeking to profit from the confusion and the fear caused by the pandemic. And on March 22nd, the DOJ requested and received a restraining order against the website's operators. So currently the website is no longer functioning. And as I mentioned, FTC complaints are reaching new heights through April. The FTC's commissioner, again, reports that the top categories for coronavirus-related fraud complaints are travel and vacation-related reports, including reports about cancellations and refunds on travel, reports about problems with online shopping, mobile texting scams, and government and business imposter scams. And in addition to the DOJ, FTC, and FDA, state attorney general offices and the plaintiff's bar are closely monitoring representations of health and safety-related products being sold at this time. Manufacturers of dietary supplements, CBD-derived products, and health food and beverages should carefully review their advertising and marketing claims to ensure there's no deceptive advertising. And for business manufacturing or advertising of products during a pandemic, remember that an ounce of prevention is worth a pound of cure. And now I'll hand it over to Steve to discuss price gouging.
Thank you, Felicia. Good morning, everybody. Thanks again for joining. Chris, Jasmine, and I will now discuss price gouging statutes. What is a price gouging statute? A price gouging statute is a law that prevents suppliers from charging excessive prices for necessities during state and or federal emergency declarations. Now, states of course differ in how they define excessive price and necessity. What states have price gouging statutes? Most states have price gouging statutes that go into effect during emergency declarations like the one we're in. During this particular emergency, governors in many states, either without price gouging laws or with limited price gouging laws, have actually issued executive orders giving their attorney general's offices the authority to govern price gouging concerns and complaints. For example, Illinois' law typically applies to petroleum products or petroleum product suppliers. However, a recent executive order issued by the governor of Illinois allows their attorney general's office to enforce price gouging laws with respect to medical and household supplies. You might be asking, why does this matter now? Well, in short, attorney general's offices across the country are paying very close attention to consumer complaints of price gouging right now. As you might imagine, most of these efforts are focused on preventing price gouging of medical and cleaning supplies, but it goes beyond that, and we'll see that in a few of these definitions of necessities. A few attorney general's offices have even issued subpoenas to investigate some of these complaints. The last I saw, for example, Pennsylvania's attorney general's office issued somewhere near 40 subpoenas to different businesses. This slide has a few statements attorney general's offices that make clear that price gouging concerns are a priority right now. I won't go through them individually, but pretty much they say we're paying close attention to this and are willing to enforce our statutes. Now I want to go through some of the general components of a price gouging statute. So the first thing you might see in a price gouging statute is an emergency declaration trigger. And pretty much what that is language that specifies when the laws apply. So it might say something like, upon emergency declaration of a governor or U.S. president. The statute might also specify how long the statute would apply. So it could include some language saying, the emergency declaration for purposes of this statute expires 30 days after the declaration if no termination date is set. The law will always also specify to whom it applies, and so some of these laws, some of the statutes in some states apply to everybody in the supply chain. Other times they only apply to businesses or people that are selling directly to consumers. The statutes will include a definition of necessity or some other language defining what kind of product it governs. Now, of course, like I said earlier, necessity is defined broadly in some states, like we'll see in Missouri, or in some states, like Illinois, as I mentioned earlier, the law only governs petroleum products. So we'll see varying statutes or various definitions of necessity in these statutes. Perhaps most importantly, we'll see a definition of excessive price. Now, this is pretty much a definition that sets, maybe just going through examples might be more helpful. So these could be very specific. Something that says a prima facie evidence of price gouging would be if a price was sold, if the price at which the product was sold was 20% higher than the price at which the same product was sold the day immediately before the emergency declaration. Now, in that example, the day immediately before the emergency declaration would be what I'm calling a look-back period, and essentially that's just a time frame from which you can use to compare the prices at which the products are selling during the emergency declaration period and how at the price at which they were being sold before the emergency declaration period. I think this will be make a little more sense when we go through some of these examples. And of course, the fifth component in these price gouging statutes are the penalties that apply for violators. Now let's walk through a few of these statutes. In Missouri, the emergency statute is triggered by a federal or state emergency declaration. And it also specifies the duration. So here, if no other termination date is set, in Missouri, the statute will apply for 30 days. The statute applies to everybody. So there's no, some, like I said, some are limited to businesses that are only selling to retailers. Missouri statute is not limited in such a fashion. And here we have a broad definition of necessity. The definition is all materials and services related to, but not limited to, food, water, medical treatment, sanitation, construction, repair, and transportation. In Missouri, the definition of excessive price is a seller's price that is not justified by the seller's actual cost of acquiring, producing, selling, and delivering the product, plus the seller's usual and customary profit margin prior to the onset of the natural disaster. And so this look-back period in Missouri is fairly general, but they are, in essence, you're comparing the price at which you're selling it now to the period immediately before the natural disaster. Penalties under the Missouri statute, price gouging is an unfair practice under the Missouri Merchandising Practices Act, which provides for the recovery of actual damages, punitive damages, attorney's fees. It also allows for actions to be brought as possible class action proceedings. Now let's turn to Illinois. Illinois' statute applies during market emergencies. A market emergency is pretty much any disruption in the petroleum products market resulting from severe weather, convulsion of nature, pretty much any other declaration of national or local emergency or other extraordinary adverse circumstances. Like I mentioned before, this statute typically only applies to petroleum-related businesses, but on March 16th, Governor Pritzker issued an executive order extending the state's authority to police these price hikes to household products and medical supplies. Again, like I said, the Illinois statute is limited to petroleum products, but here it's opened up a little broader for this particular emergency. Illinois defines excessive price as an unconscionably high price, and that's defined as the amount charged. A price is unconscionably high when the amount charged represents a gross disparity between the price of the petroleum product and either A, the price at which the same product was sold immediately prior to the onset of the market emergency, or the price at which the same product is readily obtainable by other buyers in the trade area during that emergency. The penalties under the Illinois statute, price gouging is considered an unfair and deceptive act that can be pursued as an individual or class action under the Illinois Consumer Fraud and Deceptive Businesses Practices Act. That act allows the plaintiff to recover 3 times the prohibited fees or a minimum of $1,000 per violation, in addition to punitive damages, attorney's fees, and costs. And now I'll turn it back over to Chris, who will be discussing the price gouging laws in Kansas and Pennsylvania.
Thanks, Steve. So we're going to talk about a couple more states here and their patchwork of price gouging rules and regulations. Now, and keep in mind as we go through these are examples, but the vast majority of states either have price gouging statutes or have used other statutes by executive order to try and control excessive prices during this time. So we're giving you some examples of ones that are particularly interesting or unique, but there is definitely a patchwork of state law as we look across the 50 states of the country. So let's talk briefly about Kansas, and I'm not going to read all of these, but I'll just give you some of the very basic highlights. And so like some of the other states that Steve has already talked about, Kansas limits basically the coverage of the statute to any necessary property or service. So that's obviously a wide open definition, and one that's going to adjust with the times, and one that in these current times, different things are going to be considered necessary property or service than other times. So in terms of what the excessive price is and what the regulatory guidance is for this statute, it's much broader than some of the other states. Some other states you'll see 10 to 15% price increases from pre-disaster times being, the maximum appropriate. In this case, in Kansas, it has to be 25% or greater of the price charged on the business day before the disaster declaration for it to be deemed prima facie gross excess price that could be subject to action by the Kansas Attorney General or subject to private right of action. So while Kansas has a potentially broader limit on how you can raise prices, the next provision in Kansas, which is the second sub-bullet point on this page, shows that Kansas also looks at the prices that competitors are charging, 25% greater than the price which the same product or service is obtainable by consumers in the trade area. So the watch out here in Kansas is not only do you have to look back at pre-disaster pricing that you yourself as the company charged, but also what the pricing was in the relevant marketplace. So one important thing to keep in mind, and this is true throughout the states, is for our clients and companies that we advise, do you use dynamic demand-based pricing systems and algorithms? Because if you do, then you ought to suspend those or certainly address them because obviously these statutes do regulate when and how prices can be increased and what the maximums are. So just a general watch out for those companies that have demand-based pricing, that they're either going to have to suspend those or certainly adjust their formulas and how they deal with that. Like the other states, there's a penalty, and it's also per violation, and there's also potential for private right of action, including class actions, which are the potential real exposure here on the civil side, is the ability for plaintiffs to bring class action proceedings in these states. So let's talk briefly about Pennsylvania. Pennsylvania, like Kansas and the others, the triggers are very much similar in terms of a disaster declaration and generally continues on within 30 days after the termination of the state of the emergency declared by the governor. Now, Pennsylvania is a little bit different than some of the other states. It applies to any party within the chain of distribution. So that includes manufacturers, wholesalers, retailers who are actually selling direct to consumers. So that's extremely important. These are not just statutes that are necessarily limited to direct consumer-facing companies. And Pennsylvania applies to all consumer goods and services, not those that just might be necessities of some of the other states. And Pennsylvania uses the term unconscionably excessive price, and the look-back period in Pennsylvania is 7 days immediately prior to the state of emergency. And you'll see that in this state, something is prima facie excessive or unconscionably excessive if it's in excess of 20% above the average price in that 7-day look-back period. And similarly to Kansas and the other states we've talked about, there's a penalty provision, can be enforced by the state attorney general's office, and also subject to private right of action. As Steve mentioned earlier, the Pennsylvania Attorney General has been really active in this area and has issued a number of CIDs and subpoenas to both manufacturers, wholesalers, and retailers. So this is a special, this Attorney General is particularly active in this area. So at that, I'm going to hand it off and we can hear about some more states from Jasmine Winton.
Thank you, Chris, and good morning, everyone, and thank you for joining us. I'm going to give you an overview of what California, New York, and Texas's price gouging statutes look like. I'm also going to briefly touch upon the federal government's response to price gouging in the wake of the COVID-19 pandemic. So California's price gouging statute, like most price gouging laws, is triggered by a declaration of emergency either by the president, the governor, or by a city or county executive officer or governing body that's authorized to make that kind of declaration. The statute makes price gouging illegal for certain goods and services such as food, water, emergency, and medical supplies, gasoline, and it can also extend to services such as transportation, storage services, among others. And it applies to all sellers, including manufacturers, wholesalers, distributors, and retailers, and it also covers sales to individuals and families, businesses, and other organizations, as well as governmental agencies. Now, under California's law, it includes a hard cap for price increases. In other words, a retailer cannot charge a price that exceeds more than 10% of the price of the item immediately prior to the emergency declaration. Like many states, California includes an exception to this cap for increased costs. If the seller can prove that the increase in price is directly attributable to additional costs imposed on it by the supplier of the goods or additional costs for labor or materials used to provide the services, and the price is no more than 10% greater than the total cost to the seller, plus the markup that's customarily applied by the seller immediately prior to the onset of the state of emergency or the local emergency. And note that Governor Newsom recently issued an executive order that sort of modifies these rules a bit. His executive order from April 3rd sets a specific look-back period to February 4th, 2020 for assessing certain goods, such as food items, consumer goods, medical or emergency supplies, among other items. And he's also placed additional restrictions on new sellers that did not sell such items before that February 4th, 2020 date. And so those sellers cannot sell those products for more than 50% of the amount that the person either paid for the item or the total cost of producing and selling the item, whichever one is greater. So effectively, under the executive order, new sellers may be able to sell qualified goods at higher prices than more established sellers. With respect to the penalties under the California statute, violators may be subject to criminal prosecution, which can result in up to 1 year imprisonment in county jail and or up to a $10,000 fine. Violators may also be subject to civil enforcement actions by the state attorney general and local district attorneys, in which violators may face civil penalties of up to $2,500 per violation, injunctive relief, and mandatory restitution under the California Business and Professions Code. Now, the next state we'll look at is New York, and their general price gouging statute is triggered by abnormal disruptions of the market, which can include those caused by a national or local emergency. It applies to consumer goods and services that are vital and necessary for the health, safety, and welfare of consumers. And it applies to all parties within the chain of distribution, which includes manufacturers, suppliers, wholesalers, distributors, retail sellers of consumer goods. And under New York statute, whether something constitutes a unconscionably excessive price is a question of law for the court. And in making its determination, a court may consider evidence that the amount charged represents a gross disparity between the price of the goods or services that were sold or offered for sale and their value measured by the price at which they were sold or offered for sale by the defendant in the usual course of business immediately prior to the onset of the abnormal disruption of the market. The court may also consider the amount charged and whether that grossly exceeded the price at which the same or similar goods or services were readily obtainable by other consumers in that trade area. Now, a defendant may rebut a prima facie case with evidence that additional costs were not within the control of the defendant, were imposed on the defendant for those goods and services. And under New York statute, the state attorney general is authorized to bring civil enforcement actions and may seek injunctive relief and civil penalties of up to $25,000 and restitution for consumers. The next statute is under Texas law, and it is triggered by a disaster declared by the governor or by the president. It prohibits false, misleading, or deceptive acts or practices that are actionable under the Texas Deceptive Trade Practices Consumer Act, which includes the taking advantage of a disaster by essentially selling or demanding an exorbitant or excessive price for food, fuel, medicine, lodging, building materials, or another necessity. Now, Texas statute applies to consumers, and consumers are defined to include individuals and businesses that have that have assets of $25 million or less. And the penalties for violating Texas statute, the AG may bring a civil enforcement action seeking injunctive relief, reimbursement for consumers, and civil penalties is up to $10,000 per violation, with an additional penalty of up to $250,000 if the affected consumers are elderly. In addition, consumers are authorized to recover, economic damages, damages for mental anguish, and trouble damages for knowing and intentional violations. Now, actually, I'm sorry, to go back to Texas statute, the statute doesn't give express limit or guidance as to what is an acceptable markup or what constitutes an exorbitant or excessive price. But in the past, the Attorney General has brought price gouging actions, for instance, after the Hurricane Harvey crisis, against a number of gas stations that were selling gas at excessive prices. And looking at the settlements that arose from that crisis, the AG required settling gas stations to promise not to increase their prices by more than 25% during a disaster, unless it was in response to actual increases in their costs. So this 25% figure may be a useful benchmark used when trying to assess what the Texas AG deems as an excessive price. Now, the need for critical supplies to fight the COVID-19 pandemic has led to significant activity by the federal government. As background, there's currently no federal law that directly prohibits price gouging. A lot of this is taken care of at the state level. But in light of recent price gouging concerns, the federal government has taken steps to address it. Now, while the FTC does have broad consumer protection and competition enforcement powers, they've never used those powers to bring a price gouging case, and the agency is reluctant to do so without explicit authority. So last month, the federal government has focused on curbing price gouging through invoking the Defense Production Act. So President Trump issued an executive order which delegated his authority under the Act to the Health and Human Services Secretary to basically designate certain medical supplies that must not be hoarded or sold at exorbitant prices. and these supplies included protective personal equipment such as N95 masks, hand sanitizer, and other disinfecting products. And the DOJ has basically announced the creation of a COVID-19 hoarding and price gouging task force. And on this task force, there'll be a designated designated attorney from each U.S. Attorney's Office to serve on the task force. And the task force is working closely with HHS as they designate particular items as being scarce and that should not be hoarded, and they're coordinating nationwide investigation and prosecution of the hoarding or any hoarding and price gouging of these critical medical supplies. And Attorney General Barr clarified that they're not the DOJ is not trying to pursue regular Americans who are stocking up on the necessities of daily life or businesses acquiring materials reasonably needed for their own use. They're just trying to take action against manufacturers or suppliers who are working to hoard items, and they're working closely as well with the administrator of FEMA to seize some of these necessary healthcare items and to redeploy them to areas where they are needed most. And in addition, the Senate and House Representatives have introduced new price gouging bills in the last month in Congress. Many of them are still being considered, and Congress has tried to pass this kind of legislation before, such as after Hurricane Katrina, but they were unsuccessful. So it will be interesting to see what Congress does this time around. So businesses that are selling these type of goods and services may want to keep an eye out for what Congress does with any of the proposed bills that have been introduced recently. And with that, I'll turn it back over to Felicia.
Thank you, Jasmine. And a final hurdle that is facing consumers during the pandemic is the expiration of a promotional pricing or promotional rate incentive. For example, let's say that Jane signed up for high-speed internet back in October of 2019. Now, at the time, Jane received a promotional pricing incentive of $15 off of her monthly bill for the first 6 months of her internet service. So Jane's promotional price expires after this month. Does Jane's internet service provider have an obligation to extend the promotional price for Jane and other consumers who are facing financial hardship during the pandemic? And the short answer is no. Businesses do not have to continue promotional pricing because of the current circumstances. And some examples are retail chains such as Hy-Vee and Meijer, who have completely discontinued their printed weekly flyers that contained special deals inside their stores. Still, the good news for consumers is that businesses do have discretion to offer assistance during the pandemic. In fact, some credit card service providers are offering assistance programs that temporarily grant forbearances on amounts owed if the consumer can't meet her minimum payment because of COVID-19. And while price promotions are overall decreasing in the current climate, there are businesses that have actually taken advantage of the fact that consumers are sheltering in place and relying heavily on things such as TV, internet, and streaming services. One example is Video, which is a rapidly growing prepaid streaming TV provider. Video is offering promotional pricing on all of its programming packages so that consumers can, quote, enjoy social TV for a discount, end quote. And in some instances, many argue that promotional pricing during times such as this pandemic actually does not benefit the business or the consumer. Take Lowe's Home Improvement. Last week, an unidentified store manager alerted a local news network that Lowe's would be moving forward with one of its biggest price promotions of the year, its Black Friday sale. And the tipster called this decision socially irresponsible and borderline gross negligence on Lowe's part in this time of crisis. In response, Lowe's spokesperson stated that While some retailers have taken steps to eliminate value pricing, Lowe's recognizes the importance of continuing to offer value to its customers in this time of economic uncertainty. And according to Lowe's, affordability matters now more than ever. So the final question you might be asking is whether the end of a promotional price during a crisis like this actually constitutes price gouging. Well, several state price gouging statutes recognize that discounted prices that went into effect before the declared state of emergency will not result in a violation of the price gouging laws if the price cut is now discontinued. And in these instances, businesses are allowed to use the price at which they usually sell the goods or services to calculate an increase in price, so long as that increased price still meets the required limitation in the price gouging laws. And with that, this concludes our webinar, and we'd like to open the floor to any questions.
Thanks, Felicia. This is Chris Hone back again, and we are at our time limit, but we did get a good question that I wanted to tee up for Nicole, and hopefully everybody can hang on for a minute for that question. So, Nicole, the question that we got was, if I'm interested in engaging in a competitor collaboration, what are the procedures or steps that I should take in trying to establish that?
Thanks, Chris. Happy to answer that question. So the first step is a business-related step. If you've got this idea that conceptually you think you've got a potential competitor collaboration that could fall within these guidelines, the first step would be to see if the conceptual idea and the general parameters that you're thinking of would be acceptable to the other business. And that conceptual idea of a competitor collaboration and what the parameters would look like, is it a production collaboration? Is it marketing? You know, who would do what? What would the output be? Those are all things you can discuss with your competitor without competitive concerns. What you can't do during that conversation is share any confidential proprietary information at that time. And then once you know that the other side conceptually is on board with that potential collaboration, then that's when you should work with either your in-house counsel or outside counsel to create what would be a workable framework under the antitrust laws. And then at that point is when there may be some NDAs and confidentiality agreements and putting things into place that will legally allow you to move that further down the road. But that's not something you'd want to do without being sure that the other side was conceptually on board with you. Just do that in a way where you're not sharing any competitively sensitive information.
Thanks so much, Nicole. Well, with that, we've reached the end of our webinar. On behalf of Thompson Coburn and this whole webinar panel, we truly want to thank you for your participation today. And good luck and stay healthy. And we hope you and your families stay healthy and well throughout this pandemic. Of course, if we at Thompson Coburn or anyone on this panel can help you at all or answer any questions after this webinar, please don't hesitate to give any one of us an email or a phone call. Thank you again. We appreciate it.